The United States Supreme Court declined to review a major election case involving who has the legal authority to enforce certain provisions of the Voting Rights Act. By denying review in this case, the Supreme Court left in place a highly contested ruling that came out of the 8th Circuit Court of Appeals. This denial leaves a distinct split in place between how federal voting laws are enforced in certain jurisdictions like the 8th Circuit compared to the rest of the country. Today, we're going to look at what happened in this case, the legal arguments from both sides, and why this procedural question has in fact divided federal courts. Also, how this denial by the Supreme Court may impact the upcoming elections nationwide. So let's break down what is going on. Now, before we jump into what the Supreme Court did in this ruling, if you like this type of content and you want to ensure that you get it going forward, make sure to subscribe to the channel and turn on all notifications. I also want to thank one of the main supporters of this channel, which is Attorneys on Retainer. AOR is one of the only companies and the only firms out there that does exclusively self-defense work. And so if you are a concealed carry holder and you're concerned about having legal protection if you ever have to deploy your firearm in self-defense, I highly recommend you check out AOR using the links down below. AOR has successfully represented multiple clients in hard jurisdictions like New York, Oregon, and other areas that some companies can't operate in. They just added in a new robust training division as well, which you can check out. So again, check them out using the links down below. And if you decide to sign up, you can use my code ARMSCHOLAR to save some money off of the sign-up fee, $50 off the individual fee, and $25 off the family fee. Now, to understand how this case reached the Supreme Court, we have to look at the underlying conflict between Arkansas's state law and federal laws as well. Arkansas passed a statute establishing that an individual cannot assist more than 6 voters in marking or casting a ballot during an election cycle. Assisting a 7th person actually triggers a Class A misdemeanor under the state law. The state's rationale for these kinds of caps is typically rooted in election administration, preventing improper influence, and maintaining order at polling places. However, Section 208 of the Federal Voting Rights Act states that any voter who requires assistance due to blindness, disability, or inability to read or write may be assisted by a person of the voter's choice, with narrow exceptions like their employer or a union officer. So an organization called Arkansas United, which provides bilingual volunteers to help non-English proficient voters, filed a lawsuit against Arkansas based on the law that they put in place. This organization argued that the state's 6-voter cap directly conflicted with the broad assistance guarantees of federal law, stating that they had to turn away voters during the 2020 election cycle to avoid criminal liability, and they're going to also have to turn away other voters that they want to assist during the upcoming elections. Now, on review, the federal district court who reviewed this case initially agreed with the organization, the plaintiffs here, ruling that the federal law actually preempts the state cap that was put in place by Arkansas, and it violates the supremacy clause. Now, in response, the state of Arkansas appealed. In response to that district court ruling, they appealed up to the 8th Circuit, and on review, the 8th Circuit didn't rule on whether the 6-voter cap itself is valid. Instead, they focused entirely on a threshold procedural question, which is, do private groups even have the legal standing to bring a lawsuit under Section 208? The 8th Circuit panel who reviewed this ruled that organizations do not have that standing. The court's argument relied on a strict textualist and structural interpretation of federal statutes. They pointed out that while the text of the Voting Rights Act explicitly grants the U.S. Attorney General power to bring enforcement actions like this one, it does not explicitly state that private citizens and organizations can do the same thing. Under the standard of statutory construction, if Congress explicitly names one party to enforce a law, courts generally assume that Congress intended to exclude all of the other ones. Therefore, the 8th Circuit concluded that enforcement of Section 208 is strictly the responsibility of the executive branch, not private litigants like the group here, Arkansas United. Now, on the other side of the debate, the plaintiffs here and several other dissenting judges in this case argue that this interpretation upends decades of legal precedent. Their argument is that for over half a century, the vast majority of the Voting Rights Act enforcement in lawsuits have been carried out by private individuals and civil rights groups, which courts universally have recognized their right to actually bring these lawsuits. So they contend that Congress passed the Voting Rights Act with the implied understanding that private citizens would in fact be able to act on their own to ensure that the law is actually enforced, especially given the limited resources and ability of the DOJ to bring all of these lawsuits. This disagreement has created a sharp circuit split. You have the Fifth Circuit and the Sixth Circuits, along with numerous other district courts across the nation, who have previously allowed private plaintiffs to bring Section 208 claims. Within the Eighth Circuit itself, Chief Judge Colton actually dissented in the opinion, arguing that the panel's decision deviated from historical practices and the broader consensus of federal jurisprudence, and they went against what other courts have done on this issue. Now, that ruling by the Eighth Circuit then led the group to file for Supreme Court review. They argued that the Supreme Court must grant review to the case because the Eighth Circuit's decision created a direct and stark split in conflict with settled precedent from other federal appellate courts like the Fifth Circuit and the Sixth Circuit, which have long permitted these types of private enforcement under Section 208. They contended that leaving this circuit split unresolved would result in a fractured system where federal voting protections and lawsuits are administered differently based on what jurisdiction you're in and what jurisdiction you bring that lawsuit. Furthermore, the group argued that the panel's strict textualist approach departed from decades of established practice, and that stripping private litigants of standing would severely undermine the enforcement of this law. They argue that without assistance from groups like theirs, these vulnerable voters, these individuals that could not read or write English, would be essentially dependent exclusively on the limited resources of the federal government and what they provided at the polling places. However, we recently got the order from the Supreme Court, and they denied review to this case. By denying cert, the Supreme Court has actually chosen not to resolve this split, at least for the time being. So the practical result is that in states like Arkansas, Missouri, Iowa, and Nebraska, any changes to voter assistance laws under Section 208 must be initiated by the federal government. So those lawsuits and those challenges would have to come from the AG's office. They could not come from private organizations like Arkansas United. So in other parts of the country, private lawsuits may still remain a valid avenue, but at least here, what's happening based on the Supreme Court denial and what the Eighth Circuit said, that Eighth Circuit ruling will remain in place. Also, this means, at least for now, Arkansas's law that they put in place will likely be enforceable for the upcoming election cycle. So let me know your thoughts down below on what the Eighth Circuit ruling said. Let me know what you think about this Arkansas law and the procedural finding that happened in this case and that was used to dismiss the case. Do you fundamentally agree with the Arkansas law that they put in place? Do you agree with the Eighth Circuit and the Supreme Court letting this stand, at least for now? Again, let me know your thoughts down below in the comment section. But if you like this type of content and you want to ensure that you get updates on this moving forward, make sure to like, comment, subscribe, and turn on all notifications to never miss these videos when I release them. But as always, thank you so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.